inquiry into espionage cases and the Official Secrets Act following the collapse of the case involving the alleged spying activity for China. Our objective from these sessions is to bring clarity to questions that have arisen in recent weeks, to ensure proper accountability and review the adequacy of processes and decision making. It's unusual for us to examine the details of such a case, but it is warranted given the scale of public concern. So we're going to be hearing from officials today and ministers on Wednesday morning. I'd like to remind witnesses of their obligations to Parliament and the expectation of providing as complete answers as possible. So perhaps I could start by inviting those present just to introduce themselves.
Thank you, Chair. My name is Stephen Parkinson. I'm the Director of Public Prosecutions.
I'm Tom Little, KC, First Senior Treasury Counsel, and was the instructed advocate in the case that's the primary issue of your concern.
Thank you. Stephen Parkinson, the situation we find ourselves in is quite extraordinary. Who do you think is responsible for the collapse of this case?
First of all, Chair, may I say how disappointed I am that this case could not proceed to trial. I recognise and absolutely endorse the points that you have made about the nature of this case, and in particular the level of public concern. And I'm very conscious indeed that there were two victims in this case who were members of the House of Commons, who were the victims of a gross breach of trust, as was Parliament itself. In terms of your question, if I may say so, I don't think it is a question of blame. The responsibility of prosecutors is to place cases before the court on the basis of sufficient evidence to secure a conviction. And ultimately, the issue in this case is that we were not able to provide the evidence to sustain the case in respect of one essential element, which was the element that China was an enemy, as was required by the statute.
Do you think on that point, do you think there was or did you ever get the feeling that the government wanted this case to fail?
Nothing reached me. I should, I'm sure it's known to many members of the committee, but if I may just explain the division of responsibilities in terms of criminal cases. So we don't investigate cases. We look at the evidence and we make decisions about whether it meets our tests. But the relevance of this to your question is that until a very late stage, we weren't engaged directly with any witness. That was the responsibility of the police. So I do not know anything about the background to the statements that were produced. Our responsibility was to look at the evidence, to ask investigators to obtain more evidence if that was possible, and then evaluate whether our tests were met. And the key test for prosecutors is the evidential test, which is there a realistic prospect of securing a conviction?
So you felt that you didn't have the evidence that was robust to put before a jury?
We did in the first instance.
What changed?
What changed was the ruling in a case called Rusev, which imposed an additional requirement. So, as I've explained, one of the elements of the offence was to establish that China was an enemy, and our route to doing that was to frame a case on the basis that China was a threat to national security.
Threat or an active threat?
Well, at the time, a threat. The difference that Rusev, which was another case based on the same prosecution theory, in fact, of threat to national security. There was a ruling in that case which said that you can mount a case on the basis that, in that instance, Russia is a threat to national security, but you have to show that at the material time it was an active or a current threat to national security. So the statement that we had at the time in our case didn't go that far, so we asked for confirmation that at the material time, which was the dates of the offence, China was an active threat to national security. That we did not think that this would be a difficulty, but in the end, it proved to be a sticking point, and we were unable to secure that evidence.
When you decided to drop the case, what advice did you take before coming to that decision?
Well, there was an enormously experienced team involved in this case, comprising internal lawyers, very experienced in national security cases. Mr. Little, who sits on my right, was involved at the outset and was trial counsel. So we had advice from Mr. Little, we had internal discussions, and then the way these things develop with complex and sensitive cases in the Crown Prosecution Service, senior people have to be consulted. That happened as well. And a decision was taken, which ultimately I endorsed, that we would not be able to meet our test, that there was a realistic prospect of a conviction.
And at what point did you decide that there was no alternative charges that could be pressed? Given the challenges that we'll come on to in a moment, but at what point do you decide there was no alternative charges that you might level at these two, such as plotting to or planning to commit espionage or any other similar legislation?
Well, all this was in the mix, really, at a point at which we concluded that we could not prosecute the case, and that was late August of this year. If I may, perhaps I could just bring in Mr. Little at this point, who was closely involved in advising us on the issue.
So just dealing with a couple of matters that you've raised, perhaps to try and join up some of the dots. The critical meeting, which was an unusual situation for leading counsel for the Crown to meet a witness in these circumstances, and I did that on the 14th of August, and I have a very clear recollection of that meeting because I needed to understand why the two previous attempts to get statements, statement number 2 and statement number 3 from Mr. Collins, why, as it were, what I thought would be relatively straightforward to be said, which was there was an active or current threat to national security, why that hadn't been articulated in clear terms. I also want to make it clear I was not concerned if the witness didn't use the word enemy. That would be a matter for the jury. But I needed to have the evidence to support the submission to the jury. And the witness was clear to me that he would not say that China posed an active threat to national security at the material time. That was in answer to what I regard as the million-dollar question in the case. And once he had said that, the current prosecution for those charges was effectively unsustainable. That's my carefully reflected position. I didn't jump to that immediately. I advised on the 22nd of August, having reflected over it as far as those charges were concerned. There was other discussion then about alternative charges, but I don't think anyone should misunderstand the effect of what the witness had said. That would have been disclosable, and it brought this case effectively to a crashing halt as far as that was concerned with that witness, who is the Deputy National Security Advisor to the Cabinet. It's very different to the position of giving away a witness who witnesses a criminal incident on the street for reasons that I hope are obvious. But we did give very careful consideration as to whether this was remediable. And I concluded, but more importantly we concluded, that is the entire prosecution team, that it was not.
Okay. I want to bring in Dame Emily, but just briefly, if I could, Lord Hutton.
Yes, a question really for the Director of Public Prosecutions. You said in your opening statement to us, sir, that you were disappointed that
Yes.
this prosecution couldn't be brought. And it sounds like you think that there was enough evidence, clearly, to merit a prosecution and a reasonable chance of conviction. And your argument is purely that the Rousseff case changed that.
Essentially, yes. I mean, I was disappointed. We felt that we had a good enough case to prosecute. We'd obviously spent an enormous amount of effort getting the case to the point that we did. And we felt that there should be no difficulty, in fact, in answering the question that we posed. Was China an active threat to national security at the material time? We thought that would be evidence that could be given relatively easily, but it turned out to be a sticking point. We first asked that question, so the ruling in Rousseff came out on the 31st of May 2024. We asked that question on the 11th of June. We slightly amended it the following day. It took 14 months to get the answer to that question, and the answer was no. And it took quite a lot of effort on our part to try and get the answer. But what you can't do as a prosecutor is tell people what to say. You can only obviously ask questions. But we did put a lot of effort into it, and yes, we did feel disappointed and frustrated. This was an important case.
Did it ever sort of occur to either of you that, given that if this case had gone to a trial, a jury would have had to have decided what the threat to national security was? And many people, certainly in this place, would think you can't have national security without economic security. And the Deputy National Security Advisor was very clear of the active threat to our economic security that China posed. And neither of you felt that that was sufficient basis to put an argument to the jury that that in itself could have constituted a threat to our wider security interests.
The question that was posed was, at the material time, was China an active threat to national security? The answer we got with the second statement was it was a threat to economic security. So the question wasn't answered in terms. But if I can just really reiterate what Mr. Little has said, the issue wasn't so much the statements that we were given, it was what was missing. And the key question which would have been posed in cross-examination was the question that we posed in June. Was China an active threat to national security at the material time? And the answer was that confirmation couldn't have been given. Now, can I just explain the impact of that? So the way criminal procedure works, the prosecution lays out its evidence before the court, and at the close of the prosecution case, the defence are entitled to make a submission of no case to answer. And they can do that if any element of the offence is not satisfied. And if the judge concludes that no reasonable jury properly directed could reach that conclusion, then he will stop the case. And the conclusion that was reached by Mr. Little and by our team was we were in that place. So this case would not have got to a jury because our professional assessment was that we were unable to satisfy that limb in view of that answer. So it's not so much the evidence that was given, it was that answer went to the heart of the issues and it was fatal to the case.
Can I
just add
Just bring in Dame Emily.
Can I just, may I just because I think there's quite a lot of elements here that may I do it this way? Let's start with the evidence that you first had to charge burying cash in April 24 with under Section 11C of the Official Secrets Act. What you had to prove was there was the actus reus, the guilty act, which was communicating information that might be useful to an enemy, and the guilty mind, the mens rea, for any purpose prejudicial to the safety or interests of the state, and that was an objective test. And at that stage, you had a statement, and it was from the Deputy National Security Advisor, dated the 22nd of November 23. So that's what you had. And the statement essentially said this: it proceeded on the basis that it would be proved by others that Berry had been recruited by the Chinese state as an agent, that he passed information from Cash to Berry, et cetera, all of that stuff. So he goes through all of that material and says, this is the material, this is how it was getting to China, this is who the people were who were getting it. And then the important thing, the original evidence that he gave, which you didn't get from any other source, was the evidence about the guilty mind, which was he made clear that the information was of the type passed that would be prejudicial to the safety or interest of the state, and he repeated that throughout the statement, right? So he's proving the guilty mind, others had proved the guilty acts, and what you didn't have in that first statement was you didn't have any evidence that China was an enemy, right?
We felt that, I mean, the high watermark of his evidence was his statement about the capability of China.
Are you referring to page 2, paragraph 6?
Yes.
Yes.
If I may I read it out?
Please do. Does it begin, the Chinese intelligence services are highly capable and conduct large-scale espionage operations against the UK and other international partners to advance the Chinese state's interests and harm the interests and security of the UK.
That's it.
So that's it. So you had that, but you had no more to prove at that stage that China was an enemy, right?
That was the basis upon
Right.
which we felt that we could
And the
maintain
law
the case.
at the time there was no definition within the Official Secrets Act as to who is an enemy, and these cases don't come up very often. And there had been this case called Parrott, which had come out before the First World War, which tends to show just how often these cases come up, which is not often. And in Parrott, what was said was that the law at the time was that Parrott said enemy is not defined, right? But that an enemy can be a country that one day might be at war. We might be at war with, which makes sense given it was the year before the First World War. So again, very vague, but essentially saying we're not going to say what enemy means. So that's your law at the time. You've got that one statement saying that the Chinese intelligence services are capable and conduct large-scale espionage operations, etc., etc. So that's all you've got. And what you're doing, aren't you, when you charge them, is you're thinking, right, we have these different elements, we're going to leave it to the good sense of a British jury to decide whether or not China is an enemy. At that stage, when you were charging, that was what your thinking was, wasn't it?
Well, at the stage we're charging, we had actually already begun and ultimately were successful a case based on threat to national security. And that's the case of Rousseff. I've referred to the legal ruling, but of course it was a criminal case. So...
Sorry. No. When you're charging the case, you charge on the basis of the law, right? And the law is what I've just taken some time to bring everybody through, which is the statute and a case called Parrott. And that's the law at the time, right? You may be sorting out another case that may or may not go to the Court of Appeal. It may or may not make some law. You don't know at that stage. When you're charging on the date that you did, right, which was April 24, you did it on the basis of the law then, not the law that you hoped might come at some stage in the future. You do it according to the law then.
Yes, but
right.
we took the view in both cases that the enemy requirement could be satisfied by demonstrating that the state, in one instance Russia, in the other instance China, was a threat to national security. And so that's the basis upon which we proceeded in this case.
I mean, you might have taken the view that you had evidence that China was conducting large-scale espionage operations against the UK and had recruited a couple of people who were connected with the British Parliament, and that by itself might be enough to persuade many a juror that China was an enemy, because it's hardly the behaviour of a friendly country.
The basis upon which we took the decision to prosecute was that. But what happened was that when in the earlier case, Rusev, that approach by the prosecution...
No, I will give you a chance to move on. I just want to get the basis of this clear.
Yeah.
Because what I don't understand, you see, is that if you had enough evidence to charge, why you didn't have enough evidence to carry on with the case,
yes,
and what it was that changed.
Yes.
And you say that the law was fundamentally changed by the case of Rusev, which made your evidence that you had when you charged not sufficient.
No, I'm not saying that.
If
I may, can I just finish my explanation? Yeah. So the case of Rusev did confirm that you could base a case on the threat to national security posed by another state. But what it did was to also say that if you're basing a case on threat to national security, then you have to demonstrate that at material time it was a current threat. The difference that Rusev made was that we needed to demonstrate in terms that the totality of the threats posed by China during the period of the offences made China a threat to national security. We weren't quite there on our existing evidence, and so we asked for more. We asked for a positive statement from an expert in this area. The DNSA wasn't giving evidence as an individual. He was drawing on all the resources available within government to produce his evidence. So we're asking him for that bit more. But it turned out not only to be a sticking point, but to be a critical difference.
But before we move on to the evidence that you got, or you didn't get when you tried to get more, I just want to know the basis upon which you were deciding that you needed to get more evidence. As I say, there might be many people, ordinary members of the public, who would be bringing common sense to this, this event through a jury, who might think large-scale spying on the UK, by China looks like the actions of an enemy to me.
Yeah.
So what changed it, you say, was Rusev. But don't you agree that the Court of Appeal said that it wasn't going to, this is in the case of Rusev, that they weren't going to establish a new meaning of enemy, that the term enemy should be approached in a common sense way. Now, lawyers know common sense way means that's why we have juries, because juries have so much more common sense than lawyers, frankly. And we need to get the jury to have a look and decide whether or not someone is an enemy. So Rusev is specifically saying we need to approach the idea of what is an enemy through a common sense way, i.e. we need to ask a jury. So we say that neither the approach in Parrott or Rusev was laying down a comprehensive test. They said that as well, as if you hadn't got the message from you need to ask a jury. They're now specifically saying we're not saying what a enemy is. Another country would be an enemy if the jury concluded that it was a country that Britain might one day become at war at. Well, obviously you weren't claiming, nobody was ever claiming that in relation to China necessarily. Or maybe you were, presumably you weren't. There was no reason why the term enemy should not also include a country that represents a current threat to the UK national security. That's also include. It's not this is the only way in which a country can be an enemy, is if they in future might be at war, or they represent a current threat to UK national security. They were specifically saying, we are not saying what the definition of enemy was, so you should have just gone ahead and prosecuted it.
Well, I'm sorry. Absolutely, they were saying that there wasn't a comprehensive definition. They confirmed that you can bring a case on the basis that a country poses a threat to national security. But they defined the ambit. If you're going to bring a case on that basis, they defined, as you've just read out, that there's no reason why you can't bring a case on the basis that at the material time it was a current threat to national security. So obviously, to us, it felt that we had to be four square within the ambit of what they said, which is...
No, but they said that there wasn't a clear definition. They just gave you an example, just like Parrott had given you an example of what an enemy might be. Rousseff had given you an example of what an enemy might be. But you could also have just asked a British jury, is China an enemy, particularly given the way it's been behaving?
Well, as I've explained, the view that we took, and I will invite Mr. Little to add to this, but the view that we took was that our case wouldn't survive a submission of no case to answer, and so it wouldn't get to a jury. We took the view that we'd taken rather an expansive approach to the definition of enemy, if I may say so, by, in Rousseff itself, and now in this case, saying the legal test could be met by demonstrating that China was a threat to national security. The Court of Appeal said, we agree. But it clarified what would be required, and that was to demonstrate at the material time that China, in this instance,
was a threat. Do you agree with me or not
that to national security?
You see, you're slipping back into claiming that that was the definition that the Court of Appeal was giving, but don't you agree that it's not a definition the Court of Appeal was giving, because they specifically said they weren't giving you a definition. They said this was an example and that it was up to the good sense of a jury to decide.
They said we can bring a case based on a threat to national security and define the ambit of what they meant by that, i.e. a current threat to national security at the material time. They did talk about a jury, but on the basis that there was some evidence to substantiate that. And our problem, if I may come back to this, was that our only witness on this issue was unable to confirm that at the material time China was an active threat to national security. So we didn't have the evidence.
You've got it in your first statement. You've got the Chinese intelligence services are highly capable and conduct large-scale espionage operations against the UK and other international partners to advance the Chinese state's interests and harm the interests and security of the UK. That sounds like a threat to me.
I think Mr. Little wanted to...
That was the basis upon which the charging decision was made, that it was a national security threat. I also accept that, depending on the evidence, threats to the economy, significant threats, could amount to a threat to national security. But we cannot get past, and it's unhelpful to try and ignore, the clear words of the witness who was going to be called, who did not say to me, I'm not going to say that they pose a risk to national security, but they pose a really significant economic threat, which I do regard as a significant threat to national security. He wouldn't say that. And so it's critical, bearing in mind how we put our case, and I accept that the definition is not exhaustive, but the question is, what other definition could we or should we have used? We had always proceeded on a national security basis, and common sense, I'm afraid, is not enough if I do not have the evidence to establish properly, in an admissible form, that they did pose a threat to our national security, or some other route to allow me, not just with rhetoric, to say you can be satisfied so you're sure that they are an enemy. And that's the fundamental problem with the meeting on the 14th of August 2025, because the effect of that was a total roadblock to this prosecution, and that's my firmly held
May I just let this will be my last question, and then I move on. This is my last one. You had 12 pages of evidence in the first statement of the various things, the various information that these guys had passed on to the Chinese. You know, you had and extensive, example after example, and they had been recruited by the Chinese in order to give evidence to them, in order to advance the case, in order to advance the national interest of China, and again being told that it was undermining the national interest and the security of the UK. It's not rhetoric, you had evidence.
That evidence was, as you can see from the terms of the statement, focusing in on another element of the offence, which is purpose prejudicial.
I won't ask any more questions.
Just very briefly, why didn't you put this to a judge? Was there any sort of downside to putting it to a judge just to gauge their thinking on this?
Well, there would be no basis to do so. Once the prosecution form the view that there is not a realistic prospect of conviction, we don't go and have that second guessed by a judge. That's the duty that's placed upon the director and all his prosecutors. I provide advice in that respect. But that in my submission would not be a proper way to prosecute the case, which would be to pass the buck to somebody else and let them stop the case. That's the importance of making these difficult prosecutorial decisions, which the DPP is entrusted to do.
I'm just going to bring in Lord Sedwell and then Lord Boateng. Can we hear you?
I ask the question while we're dealing with the technology.
Lord Boateng,
Yeah,
yes.
he's
The
on.
question that I have for you is this, and I recognise the difficulty and the complexity of this case and your role in it. But the threat goes beyond those excerpts that Dame Emily has helpfully read out to you, because the first witness statement also says, and I quote directly, its espionage operations, quotes, threaten the UK's economic prosperity and resilience and the integrity of our democratic institutions.
That's right.
So this isn't just a question of the economy and resilience. It goes to the heart of our national life, our democratic institutions. Neither of you have mentioned that in response to Dame Emily. So how do you deal with that? Because that would seem, on the face of it, to be the surest possible indication that we were dealing with an enemy, someone whose espionage operations threaten the integrity of our democratic institutions.
Well, as I mentioned earlier, we were satisfied on the basis of that first witness statement that there was a case to bring to court. But I'm sorry to keep repeating this, but it's such an important point that I feel I need to. That at the end of the day, on the 14th of August, the witness could not give us the critical evidence that was required by the Rousseau ruling.
Well, no, because the Rousseau ruling doesn't deal with the issue of the threat to our democratic institutions in a way that in any way alters the situation that you faced when you made the decision to charge. The statement is very, very clear. A threat to the integrity of our democratic institutions. Mr. Parkinson, in response to the chairman, you made the point that senior people had to be consulted. Was it anything, who were those senior people, and was it anything said by them that led you to reconsider your assessment of the witness statement that very clearly states the threat to the integrity of our democratic institutions?
I apologise if I was unclear earlier. When I referred to senior people, I'm talking about the internal governance within the Crown Prosecution Service. The decision-making process involved only counsel and colleagues of mine in the Crown Prosecution Service. I did inform the Attorney General of our decision, but it was the purpose of the meeting was to inform him, not to consult him.
You informed the Attorney General of your decision when?
On the 3rd of September.
And when you informed him of that decision, was there any question about the threat to the integrity of our democratic institutions?
Well, he read counsel's advice. We had a discussion. I don't recall that particular issue, but the discussion was around the fact that we were unable to satisfy the enemy requirement for the reasons that I've given.
Even though the witness said that at that time there was a threat to the integrity of our democratic institutions?
Well, the witness was unable to provide the confirmation that we sought, that China was a threat to the national security of the UK. That was the basis of our case.
So something that threatens the integrity of our democratic institutions is not a threat to the national security of the United Kingdom?
Well, I know that you are hearing from him later today, and with respect, maybe that's a question to put to him, but the question that we put to him was, can you give us the confirmation that we need in order to continue with this case? And he wasn't able to do so.
Thank you.
Lord Sebel. You're on.
Thank you. Yeah, sorry. I need to be unmuted from.
Apologies for the bells, but we will continue working through. Okay.
Okay, thank you.
So, Director, thank you. Well, as you said, we'll be putting these questions to the Deputy National Security Advisor later. My question is a simple one. You've referred to the witness, but why did you choose only to have one witness, the Deputy National Security Advisor, on behalf of the government, as your only source of evidence on this question of whether China poses a national security threat to the United Kingdom?
Well, the choice was not made by us. The choice was made by those investigating the case, but he appeared to be the most appropriate person to provide that evidence. As I said earlier, this wasn't personal evidence. He was giving evidence on behalf of the state, and the expectation was that he would draw upon all appropriate sources within government in order to frame his evidence. So he was in effect an expert. He wasn't what I might call an observational witness. An observational witness is someone who witnesses an assault or a threat. He wasn't that type of witness. He was an expert. His job involved providing advice to Cabinet on these issues. He seemed to be the best placed person, so we were told, and we were happy to accept that. I think the other thing, because questions have been raised about whether we might have drawn on other sources. And in my letter, I tried to set out not only why he was considered to be the most appropriate person, but why it would have been very undermining of our case if we'd produced another witness who was contradicting him. We don't think that the judge would actually have allowed it. But in the simple answer to your question really is that this was the witness produced to us by the investigators, and he seemed to be the most appropriate person to give that evidence.
So I understand that, Director. By the way, as I should just say for the record, I used to be the National Security Advisor, and indeed Mr. Collins used to work for me, although not as deputy. He was in a more junior position.
Yeah.
But if I can just pursue this point.
Of course. Yeah.
You've said in correspondence, etc., rightly, that you are independent of government. And so Mr. Collins is, as we've seen in his various witness statements, representing the government position. Of course, as the most appropriate person, he's there essentially as an institutional representative, not in a personal capacity as you have set out. But what you are seeking to do is demonstrate objectively to a jury that China is a national security threat to the UK, independently of government, because the government, he has reflected the government's position. And you have other evidence, for example, ISC, Intelligence and Security Committee reports, government responses, statements by various directors general of MI5, statements by people like me, former national security advisors, etc., all of whom you could have assembled to demonstrate that China is a national security threat to the UK, notwithstanding a potential concern that the government has chosen, clearly somewhat to your surprise, not to use that language themselves, presumably as a matter of government policy. So why did you, since you are independent of government, why did you not double down on that independence and secure other witness testimony that would have enabled you to demonstrate that test had been passed to a jury for the reasons Dame Emily set out?
Well, as I've said, producing other witnesses that contradicted our witness, who we were bound to call, by the way, because we needed him to establish the prejudice element of the offence, may not have been allowed, but would have undermined our case. But he did refer to the integrated reviews of both July 2021 and 2023, which set out the overall government position in relation to China. And the integrated review of 2021 didn't refer to China as a threat. It referred to China as a systemic challenge that China poses to our security, prosperity and values. And the Deputy National Security Advisor also referred to the fact that the UK wished to pursue a positive trading relationship with China, as indeed did the integrated review. So he did reference both those reviews, which seemed highly pertinent. But I come back to the point that, you know, the Crown is indivisible, and he represented the state view. He could draw on all sources. I assume he did. Most of what he says in his witness statements is actually drawn from statements of government policy of one kind or another, and those referred to China not as a threat, as they did in relation to Russia, by the way, but as a challenge, and that was insufficient.
So I do understand that point, Director, but those are statements of government policy, not statements of fact. That's the point. Integrated reviews are statements, public statements of government policy, and like all public statements of government policy, they are encompassing a range of different objectives. The simple truth with China is that it is both a national security threat and an economic opportunity, and various governments have been seeking to reconcile that tension for decades. And the fact that a government policy statement uses different language is not the same as a legal test of whether at least part of that is that China is a national security threat. And as I said, there are ample other sources of evidence associated with the Crown that state that China is a national security threat. And I entirely understand your point about the risk of contradicting the DNSA. But what you would have happened, presumably, is he would have been cross-examined, including on the evidence that Dame Emily read out and you were discussing with her earlier, alongside other evidence from former Directors General of MI5, or indeed that you could simply put on the record, because these statements are on the record, and the jury could have then made a judgment as to whether government was ducking the question of China as a national security threat for wider policy reasons, which is not the legal test. It's a government policy test, and that's what we're trying to get to.
I'll ask Mr. Littler in a second to come in on what would have happened at trial. But if I may say so, I completely agree with you. We were looking to the DNSA to provide evidence of the actual threat. I've said this in my letter, not what government policy was. But it appears he was unable to go beyond the government policy position. In the conference on the 9th of September, he said to Council that in relation to the 2021 to 2023 situation, he would not say that China was an active threat. And he went on to say successive governments had declined to categorise it as such. So we were looking to him to provide evidence of what the threat was in actuality. But in terms of what he was prepared to say, he was not prepared to go beyond that. But
that's my point. He was stating government policy, and you were asking for an evidential test.
Yes.
He was unwilling to go beyond government policy and thus provide you with your evidential test, and we will interrogate him on that in the later session.
Yes.
My question is, knowing that, why did you not choose to draw on alternative sources of evidence, including from state servants, that did meet that evidential test? Because what it appears to be the case is, in effect, a government policy became your test rather than an evidential test.
I understand the point entirely, and I agree that looks like the position that we had reached. But we were bound to call the DNSA. He had to be called.
Of course.
And so he would have faced that question. And you confirm, etc. And he would not have been able to give that confirmation.
Well, he might have found under cross-examination that he had to go further than he was comfortable doing, because you would have had a range of other evidence, including from Directors General of MI5, including from the Intelligence and Security Committee, including for the government itself in response to the Intelligence and Security Committee, including his own initial witness statement, which you could easily have said, well, you know, Mr. Collins, you may now say you're not willing to say that, but all of this evidence demonstrates that that the government has accepted the China's national security. Isn't that the case?
Yeah. Can I bring in Mr. Little, because he's the expert on what happens in trials?
If a criminal trial was an inquisitorial process, yes, but he was my witness, so I couldn't cross-examine my witness about inconsistent statements from his own, from other emanations of the state. That's just not permissible in a criminal trial. Nor, in fact, can I call witnesses to impugn the credibility of my own witness when he is the Deputy National Security Advisor. This is not the position. This is straightforward criminal procedure. This is not the position of two eyewitnesses to something that takes place, and I can say to the jury, you can accept this witness on A and B but not C because they're mistaken about that for the following reasons. We're simply not in that territory, and I'm afraid the principle of indivisibility is a real problem for the prosecution in this case. Were it not so, and I could have put him into the witness box and cross-examined him myself, but that's simply not how a criminal trial works. I would have to have asked him in examination in chief what the position was in relation to the threat, because it would have looked awful if he'd been just cross-examined on that. And he would, I am sure, have been consistent with what he told me repeatedly in conference. And he didn't tell me in conference, look, I could say so much more in private, or I could say so much more about the threat, but I can't because I have to just set out what the policy is. So having made the decision to rely on this witness, we could not give him away. He's a witness of truth. I have no reason to doubt him. I am forced to call him, and it is open season for the defence. And my view was that the judge would not in those circumstances have allowed us to call inconsistent evidence from no doubt very eminent and experienced witnesses who would have been able to comment on it. And that is a really important issue which everyone has to understand the realities of a criminal adversarial trial process. I would have to have called this witness first, and that would have been fatal.
Right, I'm just very conscious of time, and we're going to run out of time.
I'm going to be very brief.
I'm sorry, look, I'm going to bring in Dame Emily.
I've got one question. Because you've said that you decided to rely on this witness, and he had made it clear from the outset, before anyone was even charged, that he was not going to call the Chinese an enemy because of government policy. Government policy being Conservative Party policy at the time, but it continued throughout the time of his having had statements taken from him. Yeah. That's correct, isn't it?
It is correct. And we were conscious of that when we made the decision to prosecute. But we concluded that we would be able to prosecute on the basis of threat to national security, and you didn't need to use the word enemy. By basing a case on threat to national security, we would meet the legal requirement. So it's not a question of using a word, it's can we satisfy the legal requirement, and we felt that our case did at that point.
Isn't it clear the government just wanted to collapse the case?
Gavin, I'm sorry, we have to move on. Okay. Edwin Morello.
Thank you, Chair. Just quickly so I'm clear on the timeline, you mentioned before that you had met with Mr. Little and the prosecution team and key advisors in the CPS before you made the decision not to proceed with the case. Do you make that decision, or do you make the decision based on the advice of others?
Well, the decision was actually made by the head of the special crime team, and then reviewed by others, including by myself. But the decision making took place at a lower point in the organisation, but it was endorsed by me. I mean, in practice, obviously, you know, we prosecute 450,000 cases a year. I see only a tiny number of those. I am cited on the most complex and sensitive cases, and I can intervene.
But in practice, you are reliant on the advice of others.
Yes, but having said that,
at the risk of the Chair's wrath, I must ask the question and allow others to ask the...
May I just complete my answer? Obviously, given the volume of cases, I do rely heavily on my colleagues, but with the complex and sensitive cases that come to me, I do look very carefully at them, and from time to time I do push back, and I ask more questions, and I test and I challenge. And in this case, I considered it very carefully indeed, and I concluded that the right decision had been made. I think it's important to say that.
In your view, does the National Security Act 2023 make it easier to prosecute espionage cases like this?
Yes.
Thank you. Sir Gavin.
It's very interesting, actually. I was absolutely fascinated to hear about what you were saying about, because you thought it'd be quite easy to establish an active threat to national security. Is that correct?
I think we felt that it followed from everything that had been said already.
Did you actually, when you were speaking to the government, did you explain to them the implications as to, you know, the statement as it stood, as to how that would impact in terms of the ability to prosecute?
So if I may go into just a little bit of detail, I don't want to give a long-winded answer, but
as brief as you could.
I will. I promise you. We made the request. It took some months before we had a substantive response, but on the 10th of December 2024, Council met the lawyer who'd been designated to act for the DNSA and to discuss what evidence might be given. I've seen the notes of that meeting, and it was made clear that the evidence we sought was critical. The language used was, we don't want to get into a situation in which the case is dismissed at half-time, which is the phrase lawyers use to describe a submission of no case.
So Mr. Collins would have understood by not delivering the evidence that actually most people within the security establishment would say that they believed that China was an active threat to national security. By denying that to you, he effectively had the ability to collapse the case.
Well, I assume that his lawyer explained the significance of his evidence. At the very latest, the DNSA would have understood this, because at the meeting on the 9th of September, it had already been made plain that the case could not proceed because he was unable to give the positive answer that had been sought. And so the context of that second meeting with Council, it would have been absolutely clear to him the importance of his evidence. But I'm sure that he really ought to have understood that before then.
And so he would have been absolutely clear that the case would have collapsed in that sort of position. And he would have also understood that even though there's plenty of people within the security establishment that would have agreed with the fact that there was an active threat to national security, you couldn't effectively bypass him. So in essence, there was almost an active government policy to collapse the case.
Well, I'm afraid I can't speak to what he thought. I know you're going to be speaking to him. All I can say is that he was unable to give us the evidence that we needed.
Because he would have been, a little bit as Mr. Little was touching upon, it was quite clear that with him sticking with that position, no matter who you brought forward to the jury and the judge, effectively the whole case was going to be thrown out.
That is the case. I I did say this in my letter, but I think it's worth just making this point. All routes by which we might establish that China was an enemy were closed. We couldn't go down the route of threat to national security for the reasons we've discussed. He had said we were aware that he's not prepared to say that China was an enemy or potential enemy. He was not prepared to say that China was opposed to or hostile to the interests of the UK. So there were no other options open to us. The case had to end.
You sort of closed every avenue that you could possibly go down.
Well, the consequence of the evidence he was unable to give was that the case was at an end.
Thank you ever so much.
Paul Robertson, briefly.
Thank you.
You don't want to come in? Okay. Dame Karen.
Thank you very much. There was a point that the chair made at the beginning of the session that hasn't been answered, and it leans on from the questions you've just received, which was, you say there was no other avenues you could take, but could you not have gone through a different charge, espionage perhaps?
We considered all potential charges, and this is where we ended up. But maybe I could ask Mr. Little, because I know he was advising on this.
Yeah, I mean, we gave careful thought as to the evidence that we had and whether we could change horses as far as the offence is concerned. And I want to make it perfectly clear that if I thought there was any way in which I could properly have prosecuted this on the evidential stage using another provision under the Official Secrets Act or one of the other Official Secrets Act, then we'd have gone down that route. The last thing that I wanted to do was turn up in front of the judge in charge of the terrorism list and offer no evidence in the case for all of the reasons that are obvious and that the director has already raised.
Okay, thank you. So when we met previously and in response to questions that we've put, you've been very clear that what you needed was some form of a statement around the policy of the government at the time the offences were committed. Is that correct?
Well, what we needed was evidence that there was an actual threat. So we weren't asking for statements of policy. We were asking for the witness, as Lord Sedwell pointed out earlier, what we needed was evidence of fact that in actuality China was an active threat at the material time.
So the final statement, the description of China, is taken from the Labour Party manifesto. Did that undermine the case? Was that the fundamental problem?
I obviously have read in the press that there's similarity between the statement and the Labour Party manifesto, but we were unaware of that. And
that wording was the wording that meant you couldn't say that China was a threat.
No, to be clear, the problem has always been that those three witness statements were insufficient to enable us to prove the case. We needed that extra element which couldn't be satisfied. So I'm not criticising the content of the witness statements. The point that I made from the outset is that we needed more. And what was missing was a critical element.
We will ask those questions to the NSA shortly, but was there any government official, special advisor, minister or anybody that was informed prior to 1st of September that the case was potentially going to fall, potentially going to collapse?
Not to my knowledge. So the timing is that the Attorney General was informed on the 3rd of September. Prior to that, he was aware that there were issues, as he'd mentioned in his own letter.
So he was aware prior, but he didn't know that you were not going to proceed with charges?
That's right.
Okay, but he knew prior to 1st of September that there were issues with the case?
We gave him regular updates, and we explained that we were looking for a further statement from the DNSA.
And the final question. In the correspondence we've received, that after the request for the third witness statement was made, there were further emails from the CPS to clarify the ask. What clarification was required?
I think the further emails were prior to the third witness statement. CPS sent an email on the 10th of July. And the third witness statement was the 4th of August.
4th of August.
Yeah.
And Mr. Little, you met on the 14th of August, was that right?
Yes.
Okay, so it was the 4th of August was the witness statement, 14th was the was your meeting, and then the 22nd of August is the advice that you couldn't proceed, just so that we've got all the dates absolutely clear.
Yes.
Okay, thank you.
Lord Hutton.
Could I just come back to this point about who knew what when? When was the Deputy National Security Advisor told that if he didn't provide this extra bit of evidence about China being an active national security threat, if he didn't provide that statement, that the case would collapse? Was he told that?
Well, he wasn't. That wasn't the nature of the conversation. On the 3rd of September.
Sorry, why wouldn't he have been told that? It seems the obvious question to put to him.
May I just simply want to reframe, if I may, what happened. So on the 3rd of September, as I've mentioned, I informed the Attorney General of our decision. Then later that day, I informed the Cabinet Secretary of that decision and explained the reasons for it. Then the DNSA came in at the conclusion of that meeting, and I informed him of our decision. It was clear from the conversation that then developed that he felt he could offer more. He said that the meeting with counsel had been brief. So I reached the conclusion that no further steps should be taken in this case until the DNSA had had a further opportunity to meet with counsel. So that's the way the conversation developed. And I said, no communication, please, to anyone, because an issue has been raised that there may be more to be said. So that happened, and the second conference with council took place on the 9th of September. But the DNSA was obviously aware of the context of that meeting, which was that we'd been on the point of offering no evidence. And so he would have understood the reason for the conference and the reason for the question.
So effectively, sorry, Mr. Little, did you?
Can I just add that in the way you articulate it, I can understand why you do put it in that way, but I would never have expected a witness to effectively almost have a gun put to their head and said, you need to say this, otherwise we're going to drop the case, because you can understand what the inevitable effect and how that would be used if he then said, oh, well, they do, then we would have to have disclosed the terminology used. But your real point is, was he on notice more generally about the impact without there being a threat? I took the view, certainly on the 14th of August, that he understood what he was telling me. It was relatively brief, but actually the issues are pretty narrow that he had to deal with. It's a one question answer, and he was absolutely clear in the second meeting on the 9th of September, because it had already been raised. And although some of the language used was not identical to the previous meeting, the substance and effects of it was identical as far as my conclusion was concerned.
So he certainly knew this case was going to collapse.
Well, you'll have to ask him, but I'd be surprised if he didn't. I think I could.
Just very briefly on this thing about other charges, could you just explain to the committee why you didn't consider a charge under the Criminal Attempts Act?
In respect of which underlying...
The espionage activity of these two people, because clearly from the evidence that we've seen, they knew they were spying. They talk about, we're in it now, we're spies now. Why did you not think that they were attempting to breach the Official Secrets Act? Because it looks to me like they were.
Well, we'd still have to establish, depending on what route you're taking through the Official Secrets Act, we'd still have to establish with an attempt that there was an enemy underlying it for a Section 1 offence under that legislation. So,
but isn't... Sorry, I mean, obviously...
I don't want to give sort of legal advice on the hoof.
I really don't want to do that. But my understanding of the Criminal Attempts Act is that really, if the two people who were charged thought they were actually contravening the Official Secrets Act, that was enough to bring a criminal attempt prosecution.
No, I don't think it's as easy as a yes or no answer to that. It would depend on how that was put, but I can't see how we could have maintained an attempt here to perform what would be impossible if I didn't have any element of them being an enemy. There are sometimes lateral ways in which one can deal with certain inchoate offences in relation to conspiracies and so on and so forth, but
There was a conspiracy.
But then it looked
There
like
certainly was a
they were
conspiracy.
conspiring together, weren't they?
Okay.
Well, no, I do think this is rather important.
Yeah, well, the question is what
Why
would they...
didn't you charge him with conspiracy? Why didn't you add that to the indictment?
Well, but we would... they would still have had, in this basis, they would still have had to have been an enemy as far as that was concerned.
But by the first statement, there were espionage operations which threatened the integrity of our democratic institutions. What more do you need?
Well,
These men were conspiring to do that.
well,
That was the evidence that was contained in the first witness statement.
Well, the problem that we had, and I'll go back to it again, is the unequivocal position that the witness took in the meeting on the 14th of August. And it's important that people don't shy away from that. I was at close quarters to him. I looked at the witness in the eyes, which is something that I've scarcely ever done, absent a expert such as a pathologist. It just doesn't happen. And it happened because of how important this case was, but the effect of that discussion was, in my view, terminal as far as the charge was concerned, and we did reflect upon alternative offences, but concluded that there wouldn't be a realistic prospect of conviction in relation to them.
An espionage case couldn't have been brought because of what the witness said.
Yeah, that's the view